Hi, my name is Christopher Burgon. I own and run Christopher Burgon Solicitors. We're a specialist litigation and commercial law firm based in London. In these videos, we try to provide information that will help business owners avoid disputes or win disputes if they're in that situation. And to do that, we take recent cases and apply the facts and the principles from those recent cases to see if they will help you. Let me tell you about a case which has the name of Saxon Woods Investments Ltd versus Spring Media Investments Ltd. Saxon Woods were run by a Mr. Loy, L-O-Y, Mr. Loy. He was the main principal of that company, and Saxon Woods were shareholders of Spring Media Investments Ltd. Spring Media, they were controlled by a chap called Francesco Costas. Now, when Saxon Woods invested in Spring Media, they entered into a shareholder agreement. It was one of the terms of that shareholder agreement that Spring Media would look to be sold on and the profits distributed amongst shareholders at the end of 2019. And if that didn't happen, then a bank, a merchant bank, would be appointed to make sure that a sale happened shortly thereafter. Now, Mr. Loy through Saxon Woods and Mr. Costas through Spring Media fell out because basically 4 years after the 2019 deadline, and despite a bank having been appointed, Spring Media still hadn't been sold, so Saxon Woods still hadn't got their investment. Now, one of the interesting things, it's right at the beginning of the judgment in this case, is the judge's views on the two parties. The judge was Mr. Simon Gleeson, and he said, don't forget this was I'll tell you, this was a 15-day trial. 15-day trial. The legal cost must have been the hundreds of thousands, if not millions of pounds for that. Mr. Gleeson, the judge, he said that most of the evidence during that 15 days was Mr. Loy and Mr. Costas accusing each other of being dishonest, when actually he, the judge, didn't think that either of them had been dishonest. It's a classic case of two people desperately falling out, thinking the worst about their opponent, never actually having the courage or even the inclination to try and meet in the middle somewhere. They were just so hooked into how dishonest the other person was and how wrong that they had been, that they went through to a 15-day trial, spent hundreds of thousands, millions on court costs. So anyway, what was the case about? Well, it's from a legal point of view, the interesting point is about directors' duties, because Mr. Costas, he was the guy running Spring Media. He was effectively the managing director of it. He has the duty as a director to look after the interests of the company, of Spring Media. But at the same time, he is bound by this shareholder agreement that says by the end of 2019, Spring Media has to be sold. Now, Mr. Costas says, well, look, we did everything we could. We tried to sell the company, we did appoint a bank, we complied with the shareholder agreement, and I was complying with my duties as a director because I was looking after the best interest of the company. Now, interestingly, Mr. Loy didn't sue for breach of the shareholders agreement. What he sued for was unfair prejudice. He, as a shareholder, has had his interests prejudiced unfairly, which meant he had lost out. It's a section 994 petition, often called an unfair prejudice petition. So the court had to decide, had Mr. Costas actually breached the shareholder agreement, and if he had that affected his duties as a director, and had that in turn caused unfair prejudice and a loss to Mr. Loy. Now here's what the judge said. The judge said that just because, or even if the shareholders agreement had not been complied with, that doesn't necessarily mean that Mr. Costas was not looking after the company in accordance with his duties as a director. So just to say that again, part of your duties as a director could mean that you could breach a shareholders agreement. That would potentially lead to litigation against the company, but in some circumstances, that will be okay. It will be in the best interests of the company to do that. Having said that, Mr. Gleeson went on to say that he didn't believe that Mr. Costas had complied with the shareholders agreement. He was absolutely fundamental in that he had breached it, and he also went on to say that the breaches were so fundamental that actually he wasn't looking after the interests of the company, and he had acted in a way that was unfairly prejudicial to Mr. Loy, to the Saxon Woods Investments Ltd. So there you go, there's a case, Saxon Woods versus Spring Media, a 15-day trial based upon two men's antipathy to each other, even though both of them were acting honestly. The final point, the legal point to make is breaching a shareholder's agreement necessarily a breach of your director's duties? No, it isn't. But was it in this case? Yes, it was, and it was unfairly prejudicial to the shareholders. I hope that was helpful. If you find yourself in a position where you're in dispute with shareholders or directors in your company or a company you've invested in, then we'd love to help you, we'd love to speak to you. Speaking to us is easy. Go to the website, press on the book a meeting button, that'll take you to my calendar and we can have a 30-minute chat, absolutely free of charge, free of obligation. If you don't fancy that, drop us an email and we'll get in touch, or give us a call and we'll call you back. Finally, if you've got any comments on this video or on this case, or if you'd like to raise any further questions, please put them in the space underneath the video and we'll get back to you. Thanks very much.